A very happy Wednesday to you, and welcome to our next edition of the Elville webinar series. I'm Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator for today. Our topic today is the essentials of estate planning and elder law, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. And you're in the right place for high-level legal education. We encourage your general questions as always, so please note them in the questions panel or chat in the section on your screen, and we'll pause periodically throughout to address them. Your questions, they always add a lot of value and they help others learn, so don't be shy in posting those questions at any time. Also, yesterday by email, you received the presentation slides that Steve is going to be referencing, so those slides are also available in the section marked handouts in the panel on your screen to download at this time. We also have some professionals on today's presentation. Welcome to you as well. 1.5 continuing education hours are available for most everyone in attendance. And if I don't have your ID number or accreditation yet, please send that to me if you'd like to earn CE for today's presentation. Everyone will also receive a post-webinar feedback email right after the presentation, and we always value your feedback, so please take just a couple minutes to fill out this brief survey to share that feedback with us about the presentation. And we read and value every comment that you have to share with us. And here at Elville & Associates, we are always here as a resource for your family and you. If you have new planning that needs to be addressed, outdated documents that need to be reviewed, or perhaps another matter, Steve and our team are here to advise and counsel you every step of the way. So I'd like to offer the firm and Steve a brief introduction, and then we're going to jump right into the presentation. So you should be able to see my screen here. Elville & Associates, founded in 2010 in Columbia by Stephen Elville. We have several different practice areas that we focus on a daily basis here, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning, and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Stephen and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville & Associates, and we do that in several ways. One, through our planning processes with our clients. We have different programs to suit all families and individuals here at Elville & Associates. And also, of course, through educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We're one of only 2 firms in Maryland to have a client care program that is accredited through the Client Care Academy in Boston. We have our next continuing education event for our members in Annapolis in June. It's going to be a really fun event, and we look forward to seeing our members there. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve, our leader and managing principal. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. He's a member of many different national membership and professional organizations, just to name a few: the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker and presenter, if you haven't heard him talk before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization Steve founded in 2014. I'm very fortunate to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to us. I'd be very happy to share our story with you. I was very pleased to deliver 18 instruments down to Montgomery County School just the other day, and that is one of my favorite parts of being the director of this fine organization. It was, as the teacher said, a great end to Teacher Appreciation Week. It made my week as well. So just one of the few things and many things that we do at the Elville Center for the Creative Arts. So Steve, I'm going to go ahead and turn the presenter rights over to you. And you should see that button pop up on your end.
Well, thank you so much, Jeff, for that introduction. And I'm going to get to my slideshow. And thank you for all your good work, Jeff, and all that you do for us and for all of our clients and prospective clients. Good morning, everyone, and happy Wednesday. Jeff, is it really May 15th? I can't believe it. And Steve, it's almost Memorial Day. Yes, it is. And I hope everyone is gearing up for a wonderful Memorial Day holiday coming up. But here today, we're going to roll up our sleeves and we're going to have a working session talking about the essentials of estate planning and elder law. Thank you to everyone, professionals, special guests, clients, prospective clients, whatever your reason is for being here, family members. Thank you for taking time on a Wednesday morning to allow me the privilege of being able to teach and really walk you through a discussion this morning. I would like you to think about this morning's session as a mini masterclass on this subject. It's certainly not completely comprehensive. There's no way to do that within an hour, but we're going to begin on time, which we did, and we're going to end on time. And we know that your time is valuable. Some of you will have questions. We want to make sure we can answer as many questions as we can, but I also want you to walk away with some key concepts, something substantive that you can walk away with and you can actually use in your own life and in your own future planning or a current situation you may be dealing with. That leads me to talk about why you are here. You may be here for various reasons. Maybe you are a young person or a young couple. You've never done any estate planning. You may have minor children. You could be an older adult with grandchildren or children of your own. Some children are doing great. Other children have issues. You may have parents that are aging. You may have issues and concerns of your own about elder law and about how elder law kind of juxtaposes or melds into the world of estate planning and vice versa. Some of you have special needs children, people with disabilities. So whatever reason you are here this morning, we're very happy to have you. And I'm going to just set my timer and put you to work right away here to get you involved, get you grounded into this session. One of the things that my coaches tell me is that I am to get grounded before I start a presentation. So I go through a certain exercise to really get grounded. And I would like you to just take maybe 1 minute to try to get grounded yourself. What has brought you here today? What is any special concern that you have? I'm going to take a minute and just hit the timer, and we're just going to give ourselves about a minute. Please take about a minute to think through that issue. Why am I here today? Why am I taking valuable time on this spring morning, even though it's raining here where I'm at? It's a beautiful spring. Are your concerns about taxes, probate? Should I have a revocable trust? Do I have a need for an irrevocable trust? Do I have concerns about powers of attorney? Do I have concerns about asset protection? Whatever the concerns may be, large or small. I met with a young person yesterday that had a very small, brand new baby, and her concerns are certain concerns, of course, for the child's future and protection. All of you have certain concerns that you bring to the table, or maybe it's just making sure you're staying up with all the laws and the new ideas that come along quite often. So we'll take just a few more seconds just to allow you to use your pad, your cell phone, your pad of paper, your tablet, to get grounded about why you are here today. Okay, so we're just going to keep that very brief so we can be on time. I will throw out one other thing. One of the reasons that I think you should be here today, among other reasons that you may have personally, is to do something we don't talk about a lot. I once wrote a blog about exercising, your right as an American citizen or even non-citizens to be able to exercise your right of self-determination. So we talk about that a lot. The rights that we have to perpetuate our own independence and freedoms and right of self-determination. Well, I would argue at a very fundamental level, when you do estate planning or you update your estate planning, you are exercising your right of self-determination. So that's just a concept to think about today. So without further ado, we're going to get into the presentation. I'm going to move somewhat quickly. Again, your goal, I hope, is to get something substantive out of this and to use the presentation as a tool. We are not providing legal advice here today, even when we answer questions. We are really providing a high-level educational experience, and the questions, when we answer those, are really not a substitute for legal counseling, and they're not legal advice. So what is estate planning? So a lot of people want to know about that. What is it, and what is the process? And if you have a pen or you want to highlight something on your tablet, I would highlight the word process. Estate planning should be a process. Why sometimes estate plans do not work exactly the way they should, and what can we do to avoid that? We're going to talk about wills versus trusts and this whole idea of probate and non-probate that so many people talk about. Then we're going to kind of shift into elder law, taxation, asset protection. What are these things at a very high level? And then maybe most importantly, giving you a path forward. So it's education is what we're all about here at Elville and Associates, but education in and of itself does not get us to the finish line. We have to take action, and we want to give you a path forward. So there's all kinds of reasons to do planning. You wrote down some, hopefully just a few minutes ago. Why am I here? What is my concern? Why do I want to plan? Okay. And what is this thing that Steve is talking about, that estate plans can actually fail? They can actually fail to work the way they really should. And we're going to talk about being intentional, right? First of all, estate planning is not extremely difficult, but it does require some focus and attention. It's a journey. And if it's done properly, it can be enjoyable, it can be enlightening, it can be a time where you also look at all the other aspects of your life, your financial aspects, your tax aspects, your life insurance aspect, just your intentions, your goals and values that you have for your loved ones. So we want to be intentional. We don't want to have an unintentional estate plan, as funny as that sounds. So we want to have goals and purpose. And once we know what that is, we can get there. And I know that sounds like a contrived statement, but it's really true. If we know what our goal is, we can get there. If you don't know what your goal is, that's perfectly fine. That's why we have an educational process to have the epiphany that may pop up in the second or third or fourth meeting. I know what I want to do, and I now kind of have a clear idea of where I'm going. We want to have a goal. We want to have a purpose. So some people want to provide certainty, right? That's one of the big issues, right? We live in kind of a random environment, right? It seems like at times. Facilitate smooth administration or avoid probate administration. Maybe some person wants to do that. The vast majority of Americans want to avoid probate. So we're going to get into what probate is. We want to minimize costs or protect beneficiaries from creditors or divorce or bankruptcy. We want to minimize taxes in most cases, but that's not the goal for every single person. But most people do want to minimize taxes, or they have a special purpose. It could be a charitable purpose. It could be protecting grandchildren and providing education for grandchildren. You're going to look at your own purpose. I'm going to argue, though, that in the end, that estate planning is really about love, your love for your family, your love for your extended family, or love of your cause, your charity, or whatever that purpose is that you have. Now, estate plans can be less than optimal. This could be because of a transactional process where it happens kind of quickly. And I would argue that this is where we get the unintentional estate plan. You didn't intend for your plan to kind of go off the rails, but because you never got the education, you never got the time to develop your goals and plans and ideas, and you never had a collaborative team that we're going to talk about, you didn't really have a process. That is how plans can fail. They can also fail because of the lack of coordination of how your assets are actually flowing. So we don't want to get too far into the weeds, but I just want you to accept it on faith, if you would, the idea that estate plans can work less than what they should, less optimally than they should. And we want to avoid that, obviously. And how do we avoid that? Well, we avoid that through education. We avoid that through a defined process and participating in that process. And we also avoid it by having regular updates. The bottom bullet point here says, a lot of people don't update their planning for 19 or 20 years at a time. And I had someone just in our conference room this last week that was true for. It's true because life just takes over. We're all busy. We're all pressed for time. We are living in a very fast-paced world. Be kind to yourself and realize that life is just going to take over unless we are very intentional. So the traditional estate plan does not provide for estate planning education or the education of family members or fiduciaries, but the process-driven plan does provide for that. And the process-driven plan, if you can find one, such as the one we have at Elville and Associates, is what I would call a caring for clients model. There are quick models, there's traditional models, but then there's the caring for clients model, or what I would just simply call a model where there's a process. So if you can find a process, you can achieve good estate planning. And that's what this set of slides here is really talking about. We generally want to stay away from the traditional notion that estate planning is just a transaction. We want, however, a robust process that says, well, we're going to design the plan, we're going to understand it to the greatest degree possible, we're going to implement the plan where the funding or the asset alignment is also part of the planning. Then we're going to maintain that plan throughout our lives. And then when we are no longer living, that plan has a very high chance of working the way it's supposed to. So that process-driven plan talks about education, family education, funding and alignment of assets, and a life process. So this is what we really want ultimately, to exercise our right of self-determination and bring it home, going from point A, which is during our lifetime, to point B at our deaths, really making sure that at our deaths, assets are the way they should be titled, they should flow in coordination with our estate plan, and we have an estate plan that we understand and is updated. Let's talk about what estate planning really could be defined as. And as you look at your pad of paper or your tablet or your computer, I want you to just take a second here to define what you think estate planning is. We could take another minute on that, but I'm just going to argue that this little simple definition is a good starting point. And so I would say estate planning is about disposing of or giving away at your death your property to the people you want, to the persons or organizations we might say that you want, at the lowest possible cost. So estate planning, one very simple definition is I'm disposing of my property the way I want to the persons or organizations of my choice at the lowest possible cost. Now let's take a minute. I'm going to grab my timer and let's take 60 seconds and let's talk about this again in your own way to your own self. What is my definition of what I would want to accomplish with estate planning? We'll go about another 30 seconds on this. What issues keep you up at night? What worries you? What did you experience from the death of another loved one, God forbid, that you've experienced? What is it that you want to avoid? What is it that you want to accomplish if you're incapacitated? What goals and values do you wish to pass along once you are no longer here? Okay, so we've taken about 60 seconds on that, and thank you for your participation. Let's move on now. The second phase of the presentation here is to talk about the biggest issue in America when it comes to discussion of estate planning. What is probate and what is non-probate? And should I have a will? Should I have a revocable trust? Well, many of you on this webinar have wills or have revocable trusts, and for those of you who don't, it's not hard to implement one of those plans. So let's first start talking about a will. So the will is subject to probate. What is probate? Probate is the public process, the oversight that says, well, if I have a will, is that will valid? And have all the creditors been paid? Has everyone been notified? Has the court approved the accounting in many cases? In some cases, that's not required. And in some states, probate is more robust than others. So Maryland has a fairly robust process, as does, to my understanding, North Carolina and New York and so forth. I understand that in Virginia, probate is somewhat benign, not as robust as Maryland. But here we're talking about a public process where there's a very simple outline here that's not comprehensive. It's just to give you an idea about the probate process. Probate is the process of proving a will to be valid. And it takes about 6 to 9 months, 9 months most of the time on average, although not always. Creditors have a chance to make a claim for the amounts that may be owed to creditors. The Register of Wills has to be provided with information. The personal representative of the estate has the responsibility to administer the estate, and they have fiduciary responsibility. The cost of probate is going to vary depending on the state. I would say the average cost of probate for Maryland is around 4%, but this is not probate fees we're talking about here. This is the overall cost, the average cost of probate. The statutory fees that are allowed are around 4%. So when we think about a will, we might say, okay, well, we understand the process of probate. We understand what it is, but what assets are in probate? So a few examples would be an IRA with a beneficiary designation does not avoid probate. Does avoid probate. But an IRA without a beneficiary designation is going to go through probate. So see, an IRA or a life insurance policy that has a beneficiary designation is going to avoid probate because they are beneficiary designated assets. But those assets could still go through probate if they did not have a beneficiary. So now let's talk about other normal everyday assets. If you have a property or a piece of real estate in your name and it's in your sole name with no joint owner, that's going to go through probate. But if it had a joint owner, no probate, right? Many of you are aware of these concepts. The same thing is true of a brokerage account. Let's say a brokerage account had you as the sole owner with no joint owner and no beneficiary. That's going to go through probate because that has no joint owner and no beneficiary. But if it did have those things, a transferable on death beneficiary, that is going to avoid probate. So generally speaking, we're looking at what assets are in probate, what assets are not in probate. A will structure, for those of you who just want to implement a basic estate plan, looks like this. We have the will as the driving force, but we also have what we call the ancillary incapacity planning documents, financial powers of attorney, advanced medical directive, because we are not just planning for what happens at death with the will, we're planning for what happens during life with possible incapacity and how to avoid guardianship. We're going to talk about that more later. The revocable trust, which some of you have, and maybe you need to be updating your revocable trust, but the revocable trust avoids probate if it is properly done. So the first step with a revocable trust is to create the trust. The second step is to move assets that are the non-retirement assets into the trust. Stocks, bonds, mutual funds, CDs, even savings bonds, money market accounts, all of these things are non-retirement assets that would be moved into a revocable trust, including business assets like an LLC. And as we talked about just a moment ago, IRAs and life insurance, those assets have beneficiaries, generally speaking, and those do not go into a revocable trust. So a revocable trust is a private contract, it's a private document, it's an alternative to a will. So we can have a will, we can have a revocable trust. The revocable trust is appropriate for many people, it's not appropriate for all people. And it's a nice plan, it's a very high level plan. It's not for everyone, but for those that have the revocable trust, it has no creditor protection. So we don't get asset protection with a revocable trust. Now, we can provide asset protection for others after our death, but the revocable trust itself does not provide asset protection, and it provides no tax savings in and of itself. So these are myths, but what is generally true is that if we have a fully funded, fully aligned revocable trust that is what we want, and we pass away with our assets properly aligned, that trust is going to cost less to administer than a probate estate. This is what a revocable trust looks like. And here, the revocable trust is the driving force. You see it's taken the place of a will, but the revocable trust plan still has a will, as you see on the left top. It says, well, what if I didn't have all my assets in my trust? And of course, we want to make sure we do our very best to make sure that our non-retirement assets are in the trust, so there's nothing outside the trust that shouldn't be outside the trust. But if there is something out there like a small account or a brokerage account, that would be poured over through the will and back into the trust. You'll notice that with the trust plan, there's still powers of attorney and advance directives. So we are still planning for those two things that we at Elville Associates always talk about. Planning for life, the powers of attorney, the advance directive, and the revocable trust. The trust has a living element. That's why many times you will hear it called a revocable living trust, but also what happens at death. So the revocable trust is both a death instrument and a life instrument. Now, we've talked about wills, we've talked about revocable trust, but what about other non-probate things, transfers or devices, as I would call it? Well, joint ownership. If you have joint ownership with someone, you're going to avoid probate because at the death of one of the joint owners, it passes to the survivor. Beneficiary designations avoid probate. Life estate deeds, where we own a property for life and then we leave a remainder to others, that avoids probate. Transfer on death designations. I was just talking to a client about that yesterday. What happens at my death? Well, I'm leaving the assets transferable on death. Payable on death, like a bank account that's payable on death, and an in trust for account, which is, to my understanding, very similar to a payable on death account in some of the northeastern states. So these are non-probate transfers. So why are we focusing on those today? Well, because most people will plan with a will or a trust at a very fundamental level because they want to exercise control over the assets. You definitely can leave assets with these non-probate transfers, and some people do, but they do not provide for the same kind of control or flexibility that you would have if you did not use these transfer devices as the sole means of your estate planning. So we want to generally use these tools, these transfer devices, selectively, but we do not want to rely on them from a legal standpoint for flexibility and for the various potentialities that can occur in life, for our capacity or incapacity, and then at our death, who will survive us, how will our children receive the assets, what if our children are incapacitated, what if we have grandchildren and one of them is a special needs beneficiary. We generally don't want to provide for just this very singular point A to point B transfer of assets when we can actually have better control and better flexibility with a will or trust. Now, when we look at these transfer devices, we now start to look at, well, what if I do have a will or trust? How are my assets flowing? So that's one of the biggest issues in planning, is we don't want our plan to fail because we had a great will or trust, as you'll see in the next slide. We had a great will or trust, but we didn't really address the assets. So you see, that would be a mistake. That would cause our plan to not work the way we wanted. We would actually have a pretty much a impotent plan, a plan that was supposed to work, but it wasn't driving the assets. So we have to put those two fundamental things together, the documents themselves, but the asset alignment of how the assets will actually flow. Jeff, I'm going to take just maybe a 1-minute break here and see if there's any questions. We're about halfway through the discussion.
Thanks, Steve. No questions as of yet.
Very good, very good. Well, it's just one of those
over.
morning. We'll see if there's any questions that come up. We invite those. So now let's turn to the what happens during our life topic. What if we are incapacitated? How do we plan for this awful potentiality? Well, people are living a very, very long time. I will not lecture you on this, but we've had many people live beyond 100. Just most recently, someone lived to 104. And so the issue of what happens during our incapacity is very, very important. And arguably, of course, all the documents are important, but arguably the power of attorney, the financial power of attorney is arguably the most important of all the documents from an attorney's perspective. Because through a power of attorney, we are providing, whether or not we want tremendous flexibility in our planning, which generally is desirable. But in some family situations, the flexibility needs to be less, and there needs to be less powers that are given to the agents. But the most fundamental thing I want you to understand is this slide right here, which really says, during my life, I may or may not have an incapacity, but if I do, I am covered. I have the documents in place that say I will never have to be under a guardianship of my person or property. I'm going to avoid the court interference with my life. I'm going to avoid the loss of my right of self-determination. We talked about that earlier. And I'm going to have a financial power of attorney. I'm going to have an advanced medical directive, and I'm going to have agents that take care of me, so I never have to have a guardianship. So what we want to do is be very careful with the selection of agents, and we want to make sure, to the extent we can, to make sure that our agents will get along. And if you're blessed with a family where people get along, you are very blessed. Or if you don't have children, but you have other friends or loved ones that you can that will be your agents, you are very lucky indeed. So this is an integral part of our planning. Now, the Maryland statutory power of attorney is just one of the powers of attorney that you will see here. And this document gets updated every once in a while through the legislature. And recently, in the fall of 2023, it was updated. But beyond this, we just wanted to take away the idea today that when we have a Maryland power of attorney, there can be times when that is a very fine document to have, and that's a great thing if you have that. But for those who need to design more advanced powers, or for more custom powers because of the size of your assets or your particular family situation, we're going to want to customize these powers of attorney and perhaps use two instead of one, to actually have two sets, a set of powers of attorney, I should say, where we have a statutory form and a general power of attorney. So these are just some of the things that you will see that are in a general power of attorney. These are more enhanced powers. And for those of you who have revocable trust powers, or have a revocable trust, I should say, you're going to incorporate many of these powers into your revocable trust as well. Because remember, if we are incapacitated, this means that we are asking someone else and needing someone else to be able to step into our shoes and do the things that we could do, or at least some of the things or a lot of the things that we could have done ourselves. So this document, the financial power of attorney, is extremely important, and I can't emphasize it enough. Powers of attorney can be effective immediately. They can be effective in the future if you are incapacitated. Understanding this concept is one of the pieces of education that's very important. Many of you and many clients generally think the advance directive for them is one of the most, or the most important document. We're going to recommend that you customize your advance directive. Not everybody does that, but we recommend it, because when you think about it, your healthcare agent, your family member, they are only going to know what you wanted for your healthcare to whatever extent you ever talked about it, and most people don't talk about these things, or what you've customized in your advanced medical directive. So here, we're just giving you some bullet points of things that you could customize it with. I've had physicians as clients that actually fill out this form and actually change it and actually customize the form. So the thing to remember with the advance directive, it is not a formal document, it's rather informal, and that informality gives you the chance to update or to customize, I should say, the document to whatever extent that you would like. Advance directive is going to make you choose your agents, and when you choose agents, you're avoiding guardianship. The
Steve,
medical
we pause for a couple
yes,
questions.
go right ahead.
Thank you. First question is, how do trusts work for married couples? Does each person have their own, or is it a family trust?
Well, thank you for that question, and good morning. This is going to be dependent on your situation. I would say joint trust, one family trust for two people, is going to be more for a traditional couple, a couple that's been together for a long time, has not been married 2 or 3 marriages, has children from the same marriage. Many times these are the best. And it's where the couple traditionally, let's say, has a lot of joint assets. And remember that joint trusts came to the East Coast, to the common law states, not the community property states. They came from out west, where they were used mainly for community property states, but now are very popular in separate property states, or what we call common law states. So I think it's dependent. Now, some people it's going to be better because of their situation, or the size of their assets, or just the general nature of the assets, that we have 2 separate revocable trusts. And I would say this is just a design issue. There are some substantive issues there, but it's just really going to be a question of, the family, how long you've been married, what are the assets, and are you, quote, a traditional couple?
Okay, thank you. And next question, last one for now. How is property / family home best managed in a trust to A, minimize tax implications to an adult child who would inherit, and B, if there is more than one child, to consider or share an inheritance and avoid conflict?
Well, thank you for that question. And without knowing all the facts, I will just give you a very high level educational answer. And it just sounds like that you would have a house or residence like this in a revocable trust, let's say, because it's going to avoid probate and it's a nice tool. But you could also use a will. And then after the death of your death, now it sounds like you're leaving that house in a further trust, and that's going to provide for management for that residence. It's also going to make sure, and this may not be important in your particular situation, that when you leave a trust for a child and leave that residence in there, that Uncle Sam could never come in again and tax that trust at your child's generational level ever again for estate tax purposes. So you might say, well, minimizing the tax ramifications would be leaving it in further trust, not only for the protection of the child or the beneficiary, or to minimize estate tax. Then your third question, or the third leg of your question, I think, has to do with, how to equalize the shares. So in your will or trust, you could have, if I'm hearing the question right, you could have what I would call an equitable adjustment clause about how, if one child got the residence, how do we offset or make an equitable adjustment to the other child? So all of those things would be addressed in your will or revocable trust. And I hope I hit near the mark of your questions.
Great, thank you, Steve.
Thank you, Jeff. So the medical order for life-sustaining treatment, as we kind of get the tail end here of healthcare decision-making, is something that came out in 2013 as part of what I would call the National POLST Initiative, POLST. And so it's just something as a piece of education for you, and maybe more importantly, education for your fiduciaries, your healthcare agents, that they understand that Maryland is one of the states that requires a MOLST form, and this is a doctor's order. It's not exactly related to the Advanced Medical Directive, but is a doctor's order signed by a physician or a nurse practitioner, and we have to have this in Maryland if we go into a facility under certain circumstances. So you need to educate yourself on MOLST. We have a portion of a presentation that was given by a life care manager that we're happy to provide, but it's beyond the scope of this presentation. But MOLST is part of healthcare decision making in Maryland, I should say, and you need to educate yourself about it. And this link to the Attorney General, very boring stuff, but in some ways very essential to go on that website and learn about MOLST. Now we're going to shift gears in the interest of time. We have about 20 minutes left. We're going to talk about the current estate tax environment. So we've gone away from wills and trusts and powers of attorney. We currently have a 13,610,000 federal estate tax exemption for each individual. And this is times 2 for a spousal couple, 27.2 million. You can leave without estate tax. This is amazing stuff. This is the highest estate tax exemption we've ever seen. And next year it's going to go into the 14 million range, but then it's going to reset potentially through what is called the ATRA, the American Tax Relief Act. It started in 2010, it was reset in 2018, and now it's due to reset in January 1st, 2026. We're going to see if the estate tax exemption comes down. We estimate it will come down to somewhere around 7.2 million. So the estate tax exemption right now is very big. For Maryland purposes, it's 5 million. This is very big. And we have something called portability. So for those of you who are not aware of this, if you are married and you have not used your estate tax exemption during your lifetime, which you can use by gifting, but if you haven't done that, on the death of one of you, the survivor will be able to elect portability and use your unused exemption. So this is a simplification of the estate tax. It is in flux. Maryland may or may not lower its exemption if federal lowers their exemption, but we are dealing with a very large set of numbers right now. It may be reduced in 2026. For those of you who have tremendous assets that are using at least half or more of these exemption amounts, we may want to think about using your exemption prior to the 2026 deadline. In estate planning today, you can exercise marital control. If you're married, you can exercise. If you're not married, you can exercise lots of protection and control and further trust for others. If you are married and you are concerned about protecting assets from a new spouse, you can do remarriage protection. We're just living in a very, very liberal environment and favorable environment for estate tax and other techniques in planning, including the new Maryland Decanting Act, which came out in October of 2023 and really puts Maryland on the mainstream of estate planning, where we are no longer second to other states in our ability to utilize powerful tools that can help give us a top-level planning. Now, some people say, well, Steve, what is the difference between estate planning and elder care planning? Well, I'm just going to say, use your imagination on this. As we get older, we are, we hopefully have done our traditional estate planning. But at some point, due to age or due to asset protection concerns, or maybe concerns we have about children or their potential exposure to divorce, or whatever may be happening in our lives, that maybe we had to support a child, maybe we had to use a lot of funds, and some of you have experienced this. But now we're getting older and we're concerned about elder care. We're concerned about how will we pay for our long-term care. And this is this juxtaposition, this interaction between these two things. And I would say the biggest difference is that elder care is, elder law is concerned with disability planning, not so much just tax planning, asset preservation for long-term care, which we're going to talk about, flexibility, of course, that's important in both sides of the coin, estate planning or elder law, whether or not a person should divest their assets ahead of a long-term illness, but also do that in such a way that they can maintain control. And so there are ways to do that through Medicaid trusts and veterans benefit analysis and so forth. So elder care is housing, special needs, Social Security, Medicaid, asset preservation, all of those things tied up into that area, as opposed to just the traditional disposition of assets in estate planning and tax concerns. Now, as we get toward the latter part of the presentation, you see that we've talked a lot about process, we've talked about purpose, we've talked about education, we've talked about making sure that we understand the difference between probate and non-probate. We've talked about how to leave assets even through non-probate transfers and the risks involved with that. We've talked about incapacity planning. We've talked about the difference between, and the fundamental difference between elder care and estate planning. We've talked about estate tax And we've talked about these things very quickly, but one of the things that happened after the simplification of the estate tax planning through portability was that I observed that many people were able to think, including lawyers, able to think beyond just the estate tax issues. So there was a lot of thought now. There is a lot of thought about asset protection. And I'm going to break down this asset protection into 3 different categories just for purposes of our limited time together. I'm going to argue that most people don't understand their lifetime asset protection. They don't understand their long-term care potential asset protection, and they don't understand how to protect assets at death. So let's explore these 3 different areas. Many of you are married, some of you are not. If you are married, you can take advantage in Maryland and Delaware of something called tenants by the entireties. This is a basic form of asset protection. Life insurance is protected from the claims of creditors if you're married or single, if your children are the beneficiary, or if you're married, your spouse is the beneficiary. So proceeds of life insurance, cash value of life insurance is protected. Annuities are protected for the same reason. Qualified plans like 401ks, 403bs, 457 plans are protected from the claims of creditors, and IRAs generally are protected from the claims of creditors. Inherited IRAs that you may leave your children or others, those are not protected from creditors. We have to make that assumption, and we're going to have to think about how to protect those IRAs, which is now even more of a challenge because of the Secure Act, which was signed in 2019 and became effective in 2020. Also available are domestic asset protection trusts, such as trusts we can develop in states like Delaware, Nevada, Alaska, South Dakota, and other states that are called the asset protection states. Now, asset preservation or asset protection in the long-term care context involves the divestment of assets. So we really have to think in terms of giving away or divesting our assets in advance of an illness. In 2005, the Bush administration said, we're going to change the look period from 3 years to 5 years. So the period of time that must elapse before my assets are considered to be outside of my Medicaid estate. That's a mouthful. I have to give away my assets 5 years in advance if I apply for Medicaid benefits. So remember, long-term care Medicaid in a skilled nursing setting it pays about 85% of the long-term care costs in America, the government, the federal states, the federal government and the states. So we can use tools to try to look at the Medicaid laws at a very high level, and we can use powerful tools to try to preserve assets if that is our goal, which is not the goal of everyone. So we can use Medicaid asset protection trusts. This is an irrevocable trust strategy. It's possibly one of the most powerful tools today for many applications, not just for Medicaid. Many people are veterans that served during periods of war that are recognized by the VA and the government. This type of person may be eligible for veterans benefits, a tax-free income called the aid and attendance benefit. And through the use of a veterans trust, they may be able to use that powerful tool to leverage that benefit. Uses of trusts under wills. This is an essential thing to think about if you are married and if you have a loved one who's impaired, a person who has, unfortunately, a long-term illness, and it could lead to a long-term care situation. There are powerful strategies there. The augmented estate is a very confusing bullet point here. Let's just say that this is related to the use of trusts under wills between spouses. And Maryland's law is now very favorable since 2020 to allow for this technique where the state of Maryland can have no recovery and that the most amount of assets can be preserved, not only for the ill spouse, but once an ill spouse passes away, that assets can be left to children and other beneficiaries with no state recovery. We talked about the 5-year look back. So if we use a 5-year divestment strategy and that's successful, we can potentially preserve 100% of the divested assets. If we use a strategy that is more near term, it's something that we didn't get ahead of for 5 years, we can save about 50% of the assets through something called the rule of halves, where we can save roughly 50% of the remaining assets and still get long-term care Medicaid. Of course, there are other tools out there, long-term care insurance attached to an insurance policy, hybrid policies. These are very powerful tools outside of the legal context. So if you have long-term care insurance, congratulations. If you don't have it, or you don't have a hybrid type of approach to long-term care, you should definitely investigate that with your collaborative team, an advisor, financial advisor, a CPA, a lawyer, all working together, a life insurance specialist or long-term care specialist. This is all part of understanding and education. Life estate deeds can be used where you reserve a life estate to yourself, but you give up the power to sell the property. This is a Medicaid technique where you have divested the asset and you are waiting through the 5-year period. And in the interest of time, we're going to go now to asset protection at death. We've talked about asset protection during life. Now we're talking about asset protection, not in the long-term care context, but also asset protection at death. So this, perhaps, as strange as it may sound, may be the easiest way to achieve asset protection, and that is we've died. So when we die, we can leave trusts for others. We can protect those trusts with a spendthrift provision where the beneficiary cannot give away their assets to creditors. That creates a barrier in the trust to creditors. Structuring trustees, nothing could be more important. Jeff has a whole trustee selection workshop that we can send you on a link. And if you haven't thought about this recently, this is a very important thing in 2024. The use of special fiduciaries like a trust protector that has various powers to be able to do things that can give flexibility to trusts over the long term. Powers of appointment. Is the asset included in the estate of the beneficiary or not? Are we leaving a bloodline trust? Special needs beneficiaries. How do we care for children and grandchildren? All of these things, planning for spouses. This is asset protection, protection from remarriage, protection from bankruptcy, protection from car accidents and unforeseen events, bad business deals, things that went wrong, protecting people from themselves or the claims of creditors, or protecting their public benefits. These are the powerful tools in estate planning and elder law. I mentioned the Secure Act. For those of you who have retirement plans, which probably are most of you, these laws do not affect you, generally speaking, yourself. In other words, they don't affect your IRA or your 401k or qualified plan during your life, generally speaking. But when we pass away and we leave assets to others, we see that most estate plans need to be reviewed because of how the Secure Act says, and most of you have heard about this by now, that when you leave an IRA to someone else, they only have 10 years to take that IRA out. 10 years to, take all the assets, I should say, out of the IRA and pay the tax. So there are some exceptions, and here are the exceptions. Minor children, defined by the IRS as children who are not yet 21. These minor children are going to be exempt from the Secure Act, and then when they're 21, they are subject to the 10-year rule, but they are exempt prior to that. People that are less than 10 years younger than the plan participant, this could be a brother, this could be a sister who is 10 years older, but they are certainly not less, they are less, I should say, than 10 years younger. They are exempt. Spouses are exempt. Chronically ill people are exempt. Disabled people, people with special needs are exempt, and special needs trusts that are properly drafted are exempt. So basically, almost all plans need to be reviewed, if for no other reason than the Secure Act. Elville and Associates has a client care program, and we're proud to be one of the only firms, I think, Jeff, in Maryland that have a client care program. And we are very dedicated to this. Our next event is in June. You're invited to ask Jeff about this event. What our goal is here is to encourage clients to update. We want to encourage clients to have a path forward to not only become clients, but also to have a way to make sure that there is education for the client, for their client's family, and the client's fiduciaries, and even the client's advisors. So we want the client care program to be top of mind, but we also want to have a collaborative team. And here at Elville and Associates, we want to help you do that, as we'll see here in just a second. as we start to wrap up. If you're interested in our client care program, we're happy to talk to you about it. And I'm just going to get to the end here so we have a little bit of time for further questions, and we make sure we keep our promise to end on time. But our client care program, again, is really just to encourage clients to update. Now, I took you through the world of what's happening in estate planning and elder law rather quickly, and I just tried to give you some substantive gold nuggets there to grab onto. And I know most of you got it. For those of you who didn't, you're welcome to review this webinar again, and Jeff will be glad to send the link out once he cuts the video. But we encourage you to move forward to either review your current documents, to find out about how to go forward with planning if you've never done planning, and also to answer questions that you may have, specific or esoteric questions that are concerning to you, or perhaps it's an elder law consultation. But we not only want to educate, but we want to provide a path forward. Here at Elville & Associates, we're committed to taking care of clients and their families. All of our attorneys are committed, and we are very, very much engaged in that substantive process. Completing an estate planning questionnaire is a lot of work, I should say. This is the information that we need from you so that we can get to know you and really start to think about how do we solve issues, provide solutions. This can cause some fear, the fear of sharing information, the fear of meeting lawyers if you've never dealt with lawyers, the fear of maybe talking about death or incapacity. These are all very normal things. We want you to understand that we have high-tech facilities here at Elville & Associates. We work on 77-inch whiteboards to really be able to illustrate plans, to have an open discussion. There's nothing to fear. And remember, the main reason there's nothing to fear is that everything is confidential. The attorney-client privilege attaches even when an attorney is talking with you in a consultation. Even if you don't become a client, everything is confidential. So there really is nothing to fear, and we encourage you to relax. We want to see your existing estate planning documents if you have any, and we want you to, again, consider, do you have a collaborative team? Do you have an advisory team, a CPA, a financial advisor, an attorney, a life insurance specialist, or a life care manager, an aging life care manager, if you have a healthcare issue or a loved one with a healthcare issue. If you don't have these things in place, we want to help you form a team, and we also want to encourage your team to communicate and really become a dream team, so to speak, for your estate planning. We love your questions. Thank you for those who were asked those questions today. Please write them down, bring them to us so we can answer those questions. And our goal, just like I said earlier, and Jeff so eloquently said, we are here to serve, we are here to provide education, we are here to give you time to think, because that's a rare commodity today, to have time to think about what you want to do and how to do it and how to become educated in estate planning. I hope this has given you something to take away today, and I thank you for your time and attention. I don't know if the sun's coming out. I'm looking out the window here, but hopefully it's going to come out soon in the next day or so. Jeff, I'm going to turn it back to you, and I wish everyone a happy upcoming Memorial Day, and thank you for being here today.
Thanks, Steve. Great information as always. Always great to get back to the essentials, and no better person than you to do it. So thank you. Steve's information right there along with mine. Do have one question that we want to get to, and now would be a great time to get any final questions over to Steve and me. I know you've got a couple out there. So I do have a question that was actually emailed to me by one of our attendees. It's a really great one, Steve. And the question is, my sister and I have been left a house in Tennessee. Important that he notes he was a resident of Maryland at the time of his passing. The house has a lien on it and there is medical debt. Is there any way for me to take on the lien of the house without losing it to the medical debt?
Well, that's a great question. I think that's going to be a matter of Tennessee law, and I'm happy to help collaborate to try to get an answer to that question. I think it's going to be a question of what this debt is and whether that creditor is going to be a secured or unsecured creditor. and whether or not that creditor will make a claim against the estate, and all of those things. But it just sounds like maybe because of your willingness to do that, it sounds like there might be some way to do that. And then the other thing that comes to mind is whether or not the will, provided that the property would pass subject to liens like this, which means that it may not have to be dealt with right away, especially if it's a secured lien, meaning a mortgage or something like that. So it's complex, but I think that if you could email me, I'm happy to help you connect with a competent Tennessee lawyer, and then maybe really get to the bottom of most of those off the top of my head issues that seem to pop up there from your question. But it sounds like because of your willingness to attack the issue, there could be some resolution there. Good luck with that.
Okay, very good. So while we're waiting for our final questions, if any, as always, I'll send out the video, our slides again, some links to other webinars that we've done recently that are pertinent to today's presentation. And we have some great presentations coming up as we conclude here. We've talked about education. We always believe in that. Our planning team partners that we work with and encourage you to partner with. We have some great guest presenters coming up starting tomorrow. The Family Opportunity Mortgage, empowering families seeking to provide housing for loved ones. Marie Ritzenberg, who came in to present to our attorneys and staff here about a month or so ago, talked about this new program. She's with Main Street Home Loans, and she's going to present about this interesting program. So I encourage you to check that out. That's at 10 o'clock tomorrow, and it's on our website. I'll include the link if you haven't registered for that yet in my follow-up message. Next Thursday, May 23rd, life and long-term care insurance in today's marketplace, offered by advisor Max Reamer of the Quantum Group. He presented at our client event last November and was a great resource. He is also a great resource for a lot of our clients here at the firm. And that's one of our most widely requested presentations that we've had in our surveys over the past several months. So there you have it, long-term care and life insurance in today's marketplace. And then to round out May, we're going to have our quarterly estate and trust administration presentation offered by Steve. So we're going to welcome Steve back for one more time at the very end of May. So we'll see if we have any final questions here, and then we'll call this one a success, Steve. I think that's just going to about do it. So that's it. So thanks to everybody for being here. Hope you have a great rest of the week, and thanks for being part of the Elville webinar series and for your interest in Elville and Associates. Have a great day.